Hello, it's nice to see you again. Up until last time, I introduced 4 out of the 5 elements of a happy life: relationships, contribution, home, and respecting children's opinions. Today, I will talk about the final topic among the 5 elements of a happy life: financial dignity. Usually, when a child has a disability and becomes an adult, since the child has no income, many people hope that at least the minimum standard of living can be maintained, or aim for a bit more, such as financial stability. However, I would like to use the term financial dignity, which refers to a financial level that goes beyond stability and is sufficient to uphold a person's dignity. There is no need for further explanation. Every parent would agree that we should prepare for the financial dignity of children with disabilities. Perhaps too many parents, especially fathers, often believe that earning a lot of money is the only way to secure the future of their child with a disability, and so they focus solely on making money. As a father myself, I can't help but think that I need to earn a lot of money. So, even while I was working at a job in Korea, I spent a lot of time seriously worrying about how I could make more money. I tried proposing and launching in-house ventures, thought a lot about starting my own separate business, considered moving to a company with a higher salary, and even briefly got involved in network marketing businesses like Amway while still working at my job. To be honest, I'm the type of person who finds it hard to ask others for favors, but I think I tried anything and everything because I believed that my children's future depended on having money. In the end, although I worried a lot about it, I didn't have a knack for making money, so I wasn't able to earn a large sum. After many twists and turns, when my child turned 15, we immigrated here to Vancouver, Canada. Since then, as I planned my child's future and started working on what I'm doing now with Hero Now, I've been reflecting on and learning about what truly makes for a happy life for children and families. I'm now sharing the insights I've developed through that process. Money alone does not guarantee a happy life, but it is still an extremely important factor that cannot be left out when talking about happiness. Fortunately, here in British Columbia, Canada, I believe that even if parents are not wealthy, they can still make some preparations for their disabled child's financial stability and even financial dignity through various government supports and additional financial resources from family members. The main forms of government financial support include the Persons with Disabilities Benefit, which is a disability support payment, and the Long-Term Disability Savings Plan, known as the RDSP. In addition, there are housing-related services provided by CLBC, as well as community inclusion services that support daily living during the week. I have covered these topics in great detail in previous videos, so please refer to those videos for more information. Starting today, I will be introducing ways to prepare for financial dignity, focusing on topics such as family inheritance planning, wills, and trusts. Before I begin discussing the main content, I want to emphasize once again that what I am sharing is only general advice and not professional legal or financial counsel. In the book Happy Life, the author advises that instead of constantly postponing the creation of a perfect will and inheritance plan, it is better to make a will as soon as possible, even if it is imperfect. He also recommends reviewing your will about once every 2 years and making revisions if necessary. Wills and trusts can be prepared by the individual themselves, but sometimes a notary or a lawyer is used. If you do it yourself, it is cheaper, but if the legal requirements are not met, it could be invalid. So, if you are unsure, it is better to use a lawyer. The cost of having a lawyer draft a will seems to vary widely, especially if you have a child with a disability. You will also need to set up a trust, so the combined cost will be higher. When you have a child with a disability, drafting a will and setting up a trust is a specialized area, so it is important to find a lawyer who is well versed in this field. In my case, I prepared a will and a trust around 2015, and it cost about $1,000. In many cases, this cost seems to range from $2,000 to $4,000. This cost can increase depending on how complicated the situation is. The cost of amending a will is relatively inexpensive. After you've listened to the upcoming explanations about estate planning, wills, and trusts, and have gotten a sense of things, I encourage you to start preparing for a will and trust by filling out Worksheet 9 and Worksheet 10 in the Happy Life book. Today I will explain estate planning and wills, and next time I will talk about trusts. First, let me tell you what the purpose of estate planning is: first, to pay off debts, taxes, and other liabilities. Second, to provide a separate income deduction for your spouse. Third, to distribute your estate according to your wishes. Fourth, to maximize the size of the inheritance that goes to your family. In particular, in our case, it is to provide financial security for a child with a disability. Also, if you have children under the age of 19, it is necessary to designate a guardian. It is also to avoid delays in inheritance, family disputes, unnecessary taxes, expensive legal fees, will notarization costs, and government involvement. Lastly, estate planning is done to donate a portion of your estate to charities or causes you care about. In particular, in our case, since we are assuming a situation with a child with a disability, this page is especially important. After the age of 18, a disability benefit becomes available. However, in order to receive this, as of March 25th, 2025, there are eligibility requirements. First, the asset limit must be $100,000 or less. However, the house you live in, one personal vehicle, and amounts from the RDSP are excluded from this calculation. As for earned income, up to $1,600 per year is allowed, but if it exceeds that amount, the PWD benefit will be reduced by the excess amount. And for unearned income such as interest, investment income, or rental income, the disability benefit will be reduced by the amount of that income. Therefore, it is important to have an appropriate estate planning strategy to ensure that your child maintains eligibility for disability benefits. Now, what is the key point here? Since a child with a disability may lack the ability or capacity to properly manage the inheritance they receive, taking every possible measure to ensure your child can maintain a happy life, that is what I would call estate planning. As I mentioned earlier, building good relationships is important, especially networks. Networks can include friends, but as I said before, it also refers to the network of people around you who can help properly manage the inheritance. And when it comes to contribution, people often think only of jobs, but what we mean by contribution here includes all aspects of daily life during the week: hobbies, volunteering, and everything else. In other words, it's about what you do and how you spend your weekdays. Next, you also need to prepare for things related to your home, such as who you will live with and what kind of house you will live in. Next, you need to have a decision-making support system in place, as we discussed in detail last time. And preparing everything we'll be talking about from today, wills, trusts, trust administrators, and so on, is what we call estate planning. So what exactly do you need to prepare? First, you need to prepare a will. A will is a legal document that provides instructions for handling your estate upon your death. In the will, you designate an executor, and if you have minor children, you also appoint a guardian. You should also set up a trust for any children with disabilities. I will explain trusts in more detail in the next session. And as we discussed last time, you should also prepare things like a power of attorney or a permanent power of attorney. When planning your estate, you'll encounter notarization fees for the will, called a probation fee. While there is no inheritance tax, there is this probation fee, so you should also look for ways to minimize it. This probation fee is free for the first $25,000. For any amount above that, there is a 1.4% fee. So the larger the estate, the higher the notarization cost will be. It also means calculating the necessary amount for the estate and, if needed, preparing in advance, such as through life insurance, to ensure you have the required funds. If parents take out life insurance when they are young, they can get a large coverage amount for a relatively low premium. So I think it's a good idea for parents to sign up for life insurance while they're still young. Since I came to Canada a bit later in life, when I tried to get life insurance, I was already older. So even though I paid a pretty high premium, I couldn't get a large coverage amount. That's why I recommend signing up when you're young. As I mentioned a little earlier, since there are costs involved in notarizing a will, it's important to know what counts as an estate and what doesn't. First, let me introduce things that are not considered part of the estate. These are jointly owned assets, which are called joint tenancy. Assets held in this form of joint ownership, such as a house or a bank account, are not considered part of the estate. In other words, if a house is owned 100% jointly with a child, when the parent passes away, the house automatically transfers to the child. Also, life insurance with a designated adult beneficiary, that's not an inheritance either. Similarly, RRSPs or RRIFs with a designated beneficiary go directly to the named beneficiary, so these are not part of the estate. So if something is not part of the estate, it is not subject to probate, which means you can save on probate fees. Also, any funds donated to charitable organizations are deducted from the income that arises at the time of inheritance. Now let me explain what happens if someone passes away without a will. First, dying without a will is called intestate. It's referred to as without a will. When someone dies without a will, the estate is distributed according to the BC law called the Wills, Estates and Succession Act. A close relative must apply to the court to be appointed as the estate administrator, which results in wasted time and expenses. It usually takes more than a year, and in most cases the estate is worth more than $100,000, which means that the children may not be able to receive disability benefits from BC. So if you die without a will, these kinds of problems can arise, which is why it is recommended to make a will. Then, how is the estate distributed if there is no will? To put it simply, I will explain the case where there is one spouse and the children are from the same parents. First, the spouse receives a preferential share of $300,000. The remaining estate is then divided 50-50 between the spouse and the children. If there are 2 or more children, of course, the remaining 50% is divided equally among the children. If the residence is jointly owned, that is, under joint tenancy, the surviving spouse automatically inherits it. If it is owned as tenants in common, then the deceased spouse's share becomes part of the estate. If the residence is not automatically inherited, the spouse has the first right to purchase the residence. If there is no spouse, the estate is then distributed to the children. If there are no children either, it goes to the person's parents. If there are no parents, then the estate goes to siblings, and if there are no siblings, then to nieces and nephews. In this way, the order of inheritance is determined. Now, I will explain what happens if someone under the age of 19 dies without a will. If a guardian has not been designated, a minor child will be placed under the care of the MCFD, and the portion of the estate belonging to the child under 19 will be managed by a public guardian and public trustee until the child turns 19. In this case, there is a procedure where you must apply to the public trustee for funds needed for the child's upbringing, which can cause inconvenience in obtaining necessary living expenses. A particularly important point to note is that if a child with a disability turns 19 and requests their inheritance, they will receive it. But if the assets exceed $100,000, the child may become ineligible for disability benefits. Therefore, if your child is a minor, you must include a guardianship clause in your will. The executor of the will must send a copy of the will to the public guardian and trustee. Next, I will talk about the Wills Variation Act. When the public guardian and trustee receives the will, they will review whether the estate has been properly distributed in cases where there are children under the age of 19 or individuals with intellectual disabilities. If it is determined that the will does not provide an appropriate distribution to the spouse or children, the parties involved can apply to the court to have the will varied. A request to vary the will must be made within 6 months after the probate process begins. If the will does not provide an appropriate share of the estate to a child with a disability, the court or the public guardian and trustee of BC may also apply to have the will varied. So what you need to be careful about is that if you entrust the care of your child with a disability to their sibling and leave all of your estate to the sibling without leaving anything to the child with a disability, as I just mentioned, the court or the public guardian and trustee can apply to have the will varied. Please keep this in mind. That concludes my explanation about wills. I mentioned that there are various restrictions. For example, if your assets are less than $100,000 or in other situations I discussed, the way to resolve these issues is through a trust. Assets placed in a trust are generally regarded as a means to protect a child with a disability. In particular, assets placed in a discretionary trust are not considered the assets of the person receiving disability benefits, so they do not affect eligibility for those by it. In the case of a non-discretionary trust, only up to $200,000 is not counted as assets, but if it exceeds $200,000, the excess amount is considered as assets. I've just given you a brief explanation. I will provide a more detailed explanation about trusts next time. Let's wrap up here for today. I will see you again next time with the topic of trusts. Thank you for watching.